The Supreme Court of India's war of words with the government over the issue of appointment of judges has flooded our headlines over the past several months. Both the judiciary and the government refuse to back down in this fight over who gets to be in the driver's seat when it comes to appointing judges to the High Courts and the Supreme Court. Everyone from the Vice President to the Law Minister, Supreme Court judges, former judges, even lawyers have an opinion about what's happening. But how have we reached this stage? In this week's episode of the case study, we will discuss in detail the relevant context and the history of why the government and the Supreme Court are at war with one another and how the current system of appointing judges has developed over the years since India's independence, and most importantly, where this battle is headed next. The background of the Indian democracy is the doctrine of separation of powers. According to this, there are three pillars that hold up the democratic foundation of the country. These are the executive, the legislature, and the judiciary. It is crucial that each of these branches function independently with zero to minimal interference from the other two so that abuse and misuse of power can be avoided. The doctrine of separation of powers is aimed at strict demarcation of powers where the legislature makes the law, the judiciary interprets the law, and the executive implements the law. The doctrine of separation of powers was originally proposed by French philosopher and judge Charles de Montesquieu in 1747, 200 years before India got her independence. In his book, The Spirit of Laws, Montesquieu argued that when power is concentrated in the hands of a single person or a group of people, a despotic government emerges. To avoid this predicament and to limit the government's arbitrary nature, he proposed that the three organs of the state, that is the executive, the legislature, and the judiciary, should have a clear distribution of power. However, the doctrine of separation of powers is not applied in India in its absolute sense. Considering the complexities of governing a big and diverse country like India, it is impossible to demarcate the functions of each pillar into watertight compartments. As a result, there is an obvious overlap of powers and responsibilities of each arm. But one crucial aspect of the doctrine of separation of powers is to have an independent judiciary. An independent judiciary is an indispensable prerequisite of a free society under the rule of law. Neither the executive nor the legislature can be allowed to interfere in the workings of the judiciary directly or indirectly. In India, the appointment of judges is done by the government and the judiciary working alongside one another. The Constitution finds no mention of the collegium system to appoint judges. Rather, the collegium system has evolved through a series of judgments passed by the top court over the years. To understand how the collegium system came about, let's travel a little back in time. During the drafting of the Constitution, many different proposals were considered for the procedure to appoint judges. Eventually, the framework that made it through the Constitution required the appointment of the Supreme Court judges to be made by the President, acting on the aid and advice of the Council of Ministers in consultation with the Chief Justice of India. Thus, Article 124 came into being, which established the Supreme Court of India and laid down the procedure for appointment of judges. Article 124 Clause 2 states that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and seal after consultation with such of the judges of the Supreme Court and the High Courts in the state as the President may deem necessary for the purpose and shall hold office until he attains the age of 65 years. Provided that, in case of appointment of a judge other than the Chief Justice, the Chief Justice of India shall always be consulted. The role of the judiciary in the appointments process at this time was limited to providing inputs and advice to the President. The President was not bound by the advice of the Chief Justice or any other judge, and the judges had no veto power on the issue of appointments. Simply put, prior to 1993, the executive was the one that led and controlled the process of appointment. It was in 1958 that the Law Commission, for the first time, raised concerns regarding the manner in which judges were being appointed. The Law Commission argued that the system of appointment did not allow for the best talent to be appointed to the court, and that in many cases, executive influence exerted from the highest quarters was responsible for the appointment of some judges. The Law Commission was also critical of the emphasis being placed on communal and regional considerations in making appointments to the top court. But despite Law Commission's concerns, the system was followed without much controversy, that is, until the era of emergency. During the emergency in 1976, the government transferred 16 High Court judges without their consent in the name of national integration. Justice Sankalal Chand Seth, who was then a judge of the Gujarat High Court, was said to be transferred to the Andhra Pradesh High Court. Though he complied with the presidential order, but parallelly he also challenged it, seeking judicial scrutiny of the government's decision to issue the transfer order without taking consent from the judges first. Even though the High Court ruled in his favour and said that the appointment was invalid, the Supreme Court in 1977 said that the President in fact had the power to transfer judges with neither their consent nor the concurrence of the Chief Justice of India. The Supreme Court also, however, noted that the consultation with the CJI had to be effective and full consultation and not just a mere formality. In 1981, there were multiple petitions that were filed across several high courts, challenging the decision of the government to not appoint certain judges. The petitions also sought changes in the existing system of appointing judges, which was until then controlled only by the government. The petitioners in the case argued that under Article 124, the word consultation should be read as concurrence, effectively giving a veto power to the Chief Justice of India. But the challenge eventually failed before the Supreme Court 7-judge Constitution Bench, which in a 5:2 verdict said in the event of a disagreement between the executive and the Chief Justice on whom to appoint as a judge of the Supreme Court, the views of the executive would prevail. This would later come to be known as the first of the 3 judges case through which the current system of appointing judges has come into being. In 1993, a 9-judge bench of the Supreme Court was constituted to revisit the first judge's case and reconsider the correctness of the judgment passed by the 7-judge bench. In a historic 7:2 decision, the 9-judge bench overruled the judgment in the first judge's case and said that the Chief Justice of India must be given primacy in all matters of appointment. The majority was of the view that the Chief Justice of India was best equipped to know and assist the worth of the candidate, and therefore the opinion of the CJI should hold greater value. The bench also defended this by saying it was necessary to give preference to the CJI's opinion to eliminate executive influence in the matters of appointing judges. But at the same time, the 9-judge bench said that the primacy of CJI's opinion should be collective and not singular, meaning his opinion should be formed after consultation with the 2 senior-most Supreme Court judges, or what we now call the collegium. Thus, it was the 2nd judge's case that established beyond doubt that consultation means concurrence under Article 124, and in matters of appointment and transfers, the final authority lies with the judiciary and not the executive. The problem with the 2nd judge's case was that there was no proper procedure or manner that was laid down according to which the Chief Justice of India was to consult the 2 senior-most judges. Questions were raised on the process followed in 1998 when certain recommendations were made by the then Chief Justice of India. It was alleged that the CJI had not adequately consulted the 2 senior-most judges, and therefore, on the recommendation of the then President K.R. Narayanan, a 9-judge bench was constituted to decide on the consultation process between the CJI and his brother judges. It was then that the current system of appointing judges was first put in place. The bench held, before making recommendations to the Supreme Court, the CJI is obligated to consult 4 senior-most judges of the Supreme Court. Regarding appointment of High Court judges, the consultation shall be with 2 senior-most judges of the Supreme Court. Views of the judges should be put in writing and should be communicated to the government along with the name, and that the government is allowed to seek clarifications or send the recommendation back to the collegium, but if the collegium reiterated its decision, the centre was bound by it. In 2000, a commission headed by former Chief Justice of India, Justice M.N. Venkatachalya, in its report had suggested replacing the collegium system with a National Judicial Commission. The idea behind this commission was to reintroduce some involvement of the executive in the appointment of judges of the higher judiciary by having the law minister as part of a 5-member commission alongside 3 judges of the Supreme Court and 1 eminent person. There was an attempt made to introduce a law regarding this in 2002 by the Atal Bihari Vajpayee government, but due to the general elections being called and the Lok Sabha being dissolved, the law could not go through. 12 years later, the BJP government in 2014 introduced a new law in the parliament, the National Judicial Appointments Commission Bill, popularly known as the NJAC. The NJAC was a proposal of setting up a 6-member commission to replace the collegium system for appointment of judges. Article 124A was inserted into the Constitution through the 99th Amendment Act, which said that the NJAC will consist of the CJI as the chairperson, 2 senior judges of the Supreme Court next to the Chief Justice of India as ex officio members, the Union Minister of Law and Justice, and 2 eminent persons who will be nominated by the CJI, the Prime Minister and the Leader of the Opposition together. The bills were passed unanimously in both houses of the Parliament. The only exception was late Senior Advocate Ram Jethmalani, who categorically abstained from voting for the NJAC on a matter of principle, stating that he could not allow executive interference in appointing judges and compromise on the independence of the judiciary. Soon after the law came into being, both the NJAC as well as the 99th Constitution Amendment Act were challenged before the Supreme Court on the ground that it was constitutionally invalid. Ram Jethmalani was one of the leading lawyers who vociferously argued against the NJAC before the top court. In a landmark judgment in 2015, the Supreme Court struck down the NJAC and reinstated the collegium system for appointing judges. In a 4:1 verdict, a bench of Justices J.S. Kehar, Justice Chelameshwar, Madan B. Lokur, Kurian Joseph, and A.K. Goyal said that the judiciary cannot risk being caught in a web of indebtedness towards the government. The government did not challenge this verdict, and neither did it attempt to reintroduce the NJAC in the parliament. But that did not mean that the government accepted the verdict wholeheartedly either. Since 2015 till date, the government has constantly held out, clearing the files for appointments, that they did not have centre's unfeigned backing. As the Memorandum of Procedure does not mention any time limit within which the centre has to clear the files for appointment, the government often resorts to this loophole to make its point. And this brings us to 2022. It was in October 2022 when Law Minister Kiren Rijiju reignited the debate over the judges' appointment and said that people of the country are dissatisfied with the collegium system for the appointment of judges and that it is the government's responsibility to appoint judges in accordance with the spirit of the Constitution. While addressing the Sabarmati Samvad in Ahmedabad, the Law Minister said that he has observed that at half of the time, judges are preoccupied with deciding appointments, which causes their principal responsibility of delivering justice to suffer.
जिसको जिस चीज के लिए दायित्व दिया गया है वो उस चीज पे अपना ध्यान और अपना फोकस रहे तो ज्यादा अच्छा रहेगा. अदरवाइज हमको भी लोग कहेंगे कि हम भी एग्जीक्यूटिव एक्टिविज्म कर रहे हैं.
Merely a few days later, while speaking at the India Today conclave in Mumbai, the Law Minister once again hit out at the collegium and said that the collegium system was extremely opaque, not accountable, and needed to be reconsidered.
You've caused quite a storm in the Supreme Court of India and in the legal fraternity with a statement that you made, and if I may quote you, you said, people are not happy with the collegium system for appointment of judges. Who are the people who are not happy, sir?
Good evening. First of all, I am not critical about the judiciary or the judges, but I am stating a fact which is a reflection of the thinking of the common people of India. When we talk about system, then immediately what comes to the mind is transparency, accountability. When there is a system in place which is not accountable, which is not transparent, which is opaque, then if the concerned minister doesn't speak out, who else should? So I'm basically stating a fact which is basically a reflection of the thinking of the, especially amongst the lawyers community and the judges also. See, no system can be 100% perfect. But we definitely should look for the better system and the better practice. If you remember in 2015 when the Parliament of India passed the National Judicial Commission Act, the Supreme Court struck it down. When Supreme Court struck it down, then Supreme Court also should tell what is the better option. They did not tell the better option, but they felt that the old collegium system should continue. It is continuing. I am not satisfied with the present system. I spoke it out. And majority of judges, they agree with me because what I am saying is fact. I am not saying anything which is contrary to their belief and their understanding.
His sentiment was echoed shortly after by the Vice President and Rajya Sabha Chairman Jagdeep Dhankar in the Parliament on the 7th of December when he remarked that it was never too late to reflect on NJC. He said that the Supreme Court's 2015 judgment striking down the NJC was a severe compromise of parliamentary sovereignty and disregard of the mandate of the people.
This historic parliamentary mandate was undone by the Supreme Court on October 16, 2015 by a majority of 4:1, finding the same as not being in consonance with the judicially evolved doctrine of basic structure of the Constitution. Honorable members, there is no parallel to such development in democratic history, where a duly legitimized constitutional prescription has been judicially undone. A glaring instance of severe compromise of parliamentary sovereignty and disregard of the mandate of the people, of which this House and the Lok Sabha are custodians.
Again in December 2022, addressing the Parliament, Kiren Rijiju said that the huge pendency of cases was directly linked to judicial vacancies and that the only way to resolve this was by way of a new system of appointments. The repeated statements by the Law Minister and the Vice President did not go down well with the Supreme Court. The Supreme Court bench of Justices Sanjay Kishan Kaul, Vikram Nath and A.S. Oka asserted in open court that the Supreme Court was the final arbiter of the law, and as the law stands, the government is bound to appoint names that have been reiterated by the collegium. Without taking any names, the three-judge bench also asked the Attorney General R. Venkataramani to advise union ministers who are criticizing the collegium to control themselves. Then in January 2023, the Law Minister wrote to the CJI suggesting that the government should have a greater say in the process of appointments to the higher judiciary. The Law Ministry's proposal was for inclusion of a government nominee in a new search and evaluation committee which will shortlist the names and make the recommendations to the High Court or the Supreme Court Collegium for the judges. The Supreme Court shot down this idea completely. On the 17th of January, the Supreme Court Collegium for the first time put out detailed collegium resolutions while reiterating 4 names to be appointed as High Court judges. In these unprecedented resolutions, the Supreme Court made public the objections of the centre regarding certain appointments and also put out the details of the Intelligence Bureau reports that were relied on by the centre while rejecting these recommendations the first time around. Kiren Rijiju expressed grave concern over this move, calling it a serious issue. The law minister said that the collegium putting IB and raw reports in public domain was a matter of grave concern and that the government commenting on issues such as the NJAC does not lower the dignity of the judiciary in any way. In the resolution dated Jan 17th, the Supreme Court in categorical terms told the centre that the names being reiterated must be cleared before any other names so that the seniority is not impacted. But the centre paid no heed to this. On 3rd February, the Supreme Court sternly warned the centre that it would be compelled to take a difficult and unpalatable decision if the centre continued to delay its recommendations. Merely a few hours later, the centre cleared some of the new names that were recommended by the collegium but completely ignored the earlier names that had been reiterated by the collegium multiple times. Once again, the centre used the loophole to indefinitely sit on the names that they did not agree with. So where does this leave us? The centre has made it clear that it has no plans to reintroduce the NJAC, at least for now. Even if the NJAC was to be reintroduced, getting it through the parliament the second time around would be an uphill battle for the government, with many opposition parties having changed their stance since the 2015 NJAC judgment. Filing a review petition in the Supreme Court challenging the NJAC judgment is another possible option for the government, though unlikely to end in its favour. The grounds for the Supreme Court to agree hearing a review petition are extremely narrow, and unless some changes are made to the proposed NJAC system, it is unlikely that a review petition will make much headway. The third and the final option for the government is to bring about a new system altogether. For now, this seems to be the government's plan, but it continues to hold the cards close to its chest. In an interview to India Today, legal luminary and India's top jurist, Fali Nariman, had suggested that the solution to the executive versus judiciary war lay in the 2000 Venkatachalaya Commission report that floated the idea of the National Judicial Commission. The question is the government listening? Thank you for watching this episode of the case study. If you like this video and learned something new from it, please don't forget to encourage us by hitting that like button and subscribing and sharing this video with your friends, families, and colleagues. If there is any specific topics you feel unsure about and would like us to cover as part of the case study, you can leave your suggestions in the comments section below and also write to us at lawtodayofficial@gmail.com. As always, keep watching Law Today.